Welcome back, everyone. My name is Amy Williams Navarro. My pronouns are she, her, hers, and I am the manager of legislative affairs on NARAL's government relations team. I am really excited to be moderating this conversation and to hear from such a stellar group of panelists who I will introduce shortly. This panel is titled Roadmap to the Supreme Court, How We Got Here, Where We Go, because as many of you know, and Adrian mentioned earlier, the U.S. Supreme Court announced it will hear Dobbs v. Jackson Women's Health Organization, which is a case about Mississippi's 15-week abortion ban that directly challenges Roe v. Wade. You will be hearing more details about Jackson Women's Health from our panelists, but I have to stress that the Supreme Court's decision to take up this case is an alarming reminder that the threat to the legal right to abortion is imminent and real. And we can't forget that this is years in the making. This case is the result of the anti-choice movement's decades-long effort to overturn Roe v. Wade, despite the fact that 77% of Americans support Roe and the legal right to abortion. The truth is that there is no state where banning abortion is popular, and anti-choice efforts are out of touch with most Americans' values. And because the anti-choice movement knows that the majority of people in the United States have always supported reproductive freedom, they've relied on disinformation and manipulating the federal judiciary to roll back abortion access. It's no secret that the anti-choice movement has used abortion as a litmus test for the politicians and the judges that they support. And groups like the Federalist Society funnel hand-selected anti-choice judicial nominees to the Republican Party. And that's how we get an anti-choice supermajority on the Supreme Court, and not to mention hundreds of anti-choice judges in federal district and circuit courts. So the anti-choice movement knows that they can't win on the merits of their arguments, and they instead rely on disinformation and employ a campaign to spread falsehoods about abortion in an effort to distract from their hugely unpopular agenda. And you'll hear more about these concerted efforts at this afternoon's session on disinformation. But the good news is that despite these efforts, there is no doubt that the vast majority of people in the United States are on our side. So we are mobilizing to protect and advance reproductive freedom. We are pushing Congress to protect the right to abortion and improve access to abortion care by passing the Women's Health Protection Act, which we call Wipa. And you will also learn more about that from our panelists in a couple of minutes. So during this panel, we're going to be talking about the case before the Supreme Court and what to expect moving forward. We're going to talk about the impact of increasing attacks on reproductive freedom and how they disproportionately harm communities of color. And we are going to talk about why passing the Women's Health Protection Act is so critical in this point in time. As a logistical point, we are going to be monitoring the chat for questions, and we are going to save the questions for a block of Q&A time that we have for after the panelists' opening remarks. So with that, it is my honor to introduce Jenny Ma. And Jenny Ma is an experienced litigator and senior staff attorney at the Center for Reproductive Rights, a legal advocacy organization working on reproductive rights in the US and globally. Across the US, but in particular in the South and Midwest, Jenny has led active litigation against multiple restrictions on reproductive rights in state and federal courts. She leads the center's affirmative work and is part of the case team for the Mississippi 15-week ban headed to the U.S. Supreme Court. Jenny previously served as a law clerk to the Honorable John T. Noonan Jr. of the U.S. Court of Appeals for the Ninth Circuit and the Honorable Robert W. Sweet of the U.S. District Court for the Southern District of New York. She also worked as a litigation associate at two law firms, Jones Day and Patterson, Belknap, Webb, and Tyler, LLP, where she authored an amicus brief in Obergefell v. Hodges. She is a graduate of Columbia Law School, where she was a Harlan Fiske Stone Scholar, MS.JD fellow and received the Lewis Henkin Outstanding Note Award. She also holds a BA with honors from Wesleyan University in American Studies and Psychology and an MA from Columbia University's Graduate School of Arts and Sciences in American Studies. Thank you for joining us, Jenny. So
Thank you so much for having me.
The Center for Reproductive Rights filed this case on behalf of Jackson Women's Health Organization, which is the last remaining abortion clinic in Mississippi, to block the state's unconstitutional ban on abortion after 15 weeks. Could you tell us more about the case and what to expect moving forward?
Absolutely. But before we dive in, I do want to thank everyone who is listening, and to you, Amy, and everyone at NARAL for hosting this amazing event, and to my fellow panelists who will be diving into all of these issues. My name is Jenny Ma. Thank you for that amazing introduction. My pronouns are she, her, and I'm a senior staff attorney at the Center for Reproductive Rights. And we really find ourselves in the moment, and what I mean by that is that for nearly 50 years, Roe versus Wade has been the law of the land, and generations have come to depend on this right. This is an absolute right to pre-viability abortion without interference from any state or any government, and it is now truly in jeopardy. It's a time for all of us to really recognize what's at stake and sound the alarm for yourselves, the folks around you, the movement, and the general public. So I'm on the case team, as Amy mentioned, and today I'm going to talk to you a little bit about the background of the case and what to expect and what's at stake over the next year or so. So if we can go to the second slide, please. The next slide after that. So for starters, I'm going to do some foundation setting. We are talking about a case called Dobbs versus Jackson Women's Health Organization, and it's a case, as you heard, challenging Mississippi's 15-week ban on abortion. Now, it's part of a lawsuit that challenges actually several restrictions in Mississippi that are medically unnecessary, and it makes it very difficult for clinics to operate in that state, and also for patients to access care and make it to the clinic doors. Now, there's a whole host of other laws that I won't go into today, but just to give you a little flavor of what else folks in Mississippi have to do to even get to the door of the clinic, there's a 2-trip requirement that delays your care unnecessarily. There's a state-mandated bias counseling requirement. There's forced ultrasounds. There's a ban on telemedicine. There's burdensome facilities requirements. There's a physician-only law, and so on. So I just say that to say this is not just the only law in Mississippi that's preventing abortion care. And in fact, just in case, Mississippi also has a 6-week ban. So no bans or no laws are sufficient to prevent folks from accessing this essential health care. But those are abortion restrictions that I've talked about, right? And this part of the case, the 15-week ban case, is actually about a straight up ban on abortion after 15 weeks of pregnancy. And why that's important is that 15 weeks of pregnancy is far before viability, which is, according to science, around 24 weeks of pregnancy, right? So it's several weeks before, in fact, over 2 months before viability. And why that's important is because the Supreme Court has said for over 50 years in Roe, in cases between Roe and Casey, Planned Parenthood versus Casey, and then even after Casey, that a state cannot absolutely bar you from a pre-viability abortion. They can put up restrictions that, if it has a legitimate purpose and is not an undue burden, they can put some restrictions up, but they cannot ban any single pregnant person from accessing care prior to viability. So this is really the heart and core of the right in Roe, and this is what's at stake. Because on March 19th, the governor of Mississippi signed this 15-week ban into law. And then hours later, our team at the Center for Reproductive Rights filed a lawsuit and asked that law be stopped, meaning that it would not go into effect and be enjoined. And the very next day, a federal district court granted our emergency relief, and the ban was blocked. It went up the next level, which is the Fifth Circuit Court of Appeals. It's an appellate court. We got the same ruling and we won there. So the law was blocked again. Then on June 15th, 2020, in the middle of the pandemic, Mississippi asked the Supreme Court to hear this case, and they filed what's called cert. And the Supreme Court, as you can see from the slide, sat on this for 11 months before it announced its decision to hear the case on May 17th. So we don't know what happened between those 11 months, but that is very highly unusual. And this is one of the longest cases that the Supreme Court deliberated before we heard back. Again, I cannot say it more. This is a direct challenge to Roe. It is the first direct challenge since Planned Parenthood versus Casey. And there is no path for the Supreme Court to uphold Mississippi's ban without overturning Roe's core holding that every pregnant person has the right to decide whether or not they can continue a pregnancy up to viability. Next slide, please. And so, as I said, it should be very easy for the Supreme Court or any court or anyone out there actually to decide this case, right? Because as I said, for over 50 years, that's been the clear line. There was a dividing line. And that's what the lower courts in this case thought, right? As I mentioned, we won at every single stage, including with a very aggressive Trump-nominated judge on the Fifth Circuit Court of Appeals. We got a unanimous decision there. And, I won't read you the quotes, but they're pretty precedential. They say, like, absolutely, it's unconstitutional. There's no doubt about this because there is an unbroken line dating back to Roe that the Supreme Court has decided that this is a right that belongs to the individual. And, I think what's especially stark, which some of my colleagues, and I'll touch upon a little bit in this presentation, is that the legislature actually had professed an interest in women's health, but as the judge in the lower court found, that's pure gaslighting because there are tragedies lurking on the other side of the delivery room in Mississippi, including alarming infant and maternal mortality rates that are not being tackled, right? So the attention is certainly not where it should be. Next slide. I'm sorry, yeah. So now we just got Mississippi's actual merits brief last week, and the state has done a 180, y'all. Like, throughout all the way up, they said there's no reason that you need to overturn Roe versus Wade. And actually, now they changed their mind. They did a 180, and they now ask the court explicitly, you need to overturn Roe versus Wade. They have made their goal clear, and they're shouting it from the rooftops, right? So they say Roe and Casey needs to be overturned because it is, quote, hopelessly unworkable, quote, egregiously wrong, inflicted significant damage upon the culture and the judiciary, and saying that no one has relied on that right for the last 50 years. So the brief is publicly available. I encourage y'all to read it. I think it is an exceptionally alarming view of constitutional rights. It is not just about abortion, because the abortion right actually stands with other fundamental rights involving personal decisions about who to marry, who to have intimate relationships, the right to use contraception. All of that kind of paints a very disturbing picture in which a government can force individuals to remain pregnant against their will. And the brief just starkly erases all the people who are actually affected by this ban. Next slide, please. So Dahe will talk a little bit more about the communities impacted, but I'll touch upon some Mississippi-specific facts. Our client, Jackson Women's Health, is the only remaining clinic in Mississippi, and that's because Mississippi passed so many other restrictions that I talked about earlier that made it impossible for clinics to stick around. So that's happening all across the country, and now there's about 6 or 7 states with only one clinic. These abortion bans disproportionately affect Black people, people having difficult making ends meet, young people, and rural people. And this is especially true in Mississippi, which has the highest poverty rate in the country of any state, the highest percentage of Black folks in the United States, and the worst maternal and infant mortality rates in the country overall, but especially for Black mothers and infants. Next slide, please. Outside of Mississippi, over the last few decades, the anti-choice movement have enacted hundreds and hundreds of restrictions, right? So this year, Guttmacher called it the worst legislative year ever for US abortion rights since Roe, because about 90 state restrictions were passed. And to emphasize, it's not just Mississippi, right? There's 22 states primed to take action with what's called trigger bans, saying that they've intended to ban Roe as soon as the Supreme Court, ban abortion as soon as the Supreme Court bans Roe. Next slide, please. And so we're talking about 50 years of precedent, and that means a lot. Definitely for me as a lawyer, but also for the public, because the court should not be seen as the political actor, and the legitimacy of the court is at stake here and how it is viewed by the public. These are fundamental rights: the right to abortion and the rights beyond abortion about relationships, whom you can marry, what happens in intimate relationships, who you can sleep with, how you can use contraception, how you can design your family. It's all intertwined in our liberties. Next slide, please. So what can you expect and when? So I'm sorry, the dates are really small there, but you can kind of like see through. We're about like the third arrow in. So we got the state's briefs and the state's amicus briefs, which are called friend of the court briefs. Those are briefs that support the state. I will share with you guys that we have about 77 of those. That's a giant amount, and they're, again, all publicly available on the Supreme Court website. The next kind of date to be aware of is that our brief, so our side's brief, is due on September 13th, and we're hard at work on that. Amicus briefs on our side are due September 20th. And since we are not the ones asking the court to take this case, Mississippi gets the last word. That's October 13th. An oral argument has not been set yet, but we are expecting it to happen in late fall of this year. And so around November, although we haven't gotten it calendared, and the decision to come out sometime in June 2022. Next slide, please. So after presentations like this, I'm always like, okay, so yikes, despair, what can I do, right? So I want you guys to just take a few deep breaths. It's a marathon, not a race, right? We need to keep up our strength on our side. So keep up that drum beat. Just a little list here for things that you can do. Obviously, you're going to learn a lot about things you can do, like lobbying from the fine folks here at NARAL, and to support and educate and advocate on behalf of these issues. Read up, right? Like go to the SCOTUS case and like take a look at that, read about abortion restrictions and what's happening in your state and across the country. And advocate in so many different ways, right? You're going to learn about one way to advocate here this weekend, but like advocacy can happen like at the dinner table, like talk about what's going on in this country, really talk to your friends and family. It could be at the upper echelons of Congress and your state legislatures. The kind of people power that you harness by learning about this and kind of relaying it as a messenger is what's really going to be so helpful. And support your clinics. Jackson Women's Health obviously is going through a really intense time right now, but other clinics in the South and Midwest are also worried about their existence. Support abortion funds, support clinic escorts who are on the front lines every day, dealing with protesters and making sure patients get into that door without too much harassment. And you can follow the case updates from the Center for Reproductive Rights. And, there will likely be an argument on Rally Day if the argument's in person at the Supreme Court. So if you can make it to DC, join us and join NARAL and the folks in this movement who will come out. It's really, having been to 2 of them before for Whole Woman's Health and for June Medical, it's a really wonderful day to be with the movement. And it's a wonderful way to support this fight. So I really urge you all to take all sorts of different actions in whatever ways that you feel comfortable doing, and to hear more about this from my fellow panelists. Thank you so much.
Thank you, Jenny. It's really wonderful to have you here with us. It's so unique to hear from someone who is actually on the team case, or the case team. So we will move on to our next panelist. It's my honor to introduce Dahae Kim. Dahae currently serves as the Legal Advocacy and Judicial Strategy Manager at the National Asian Pacific American Women's Forum, known as NAPAWF. Prior to joining NAPAWF, she worked as a staff attorney for a legal aid organization that serves low-income residents in rural Northern California. She represented tenants facing eviction and represented clients to advocate for increased access to Medicaid-funded services and for receipt of entitlement programs. She also served as a coordinator during the campfire in 2018, helping to bring pro bono legal services to the area and representing clients with their FEMA assistance appeals. She graduated with double majors in sociology and political science from the University of Georgia and received her JD from University of California, Berkeley School of Law. Thank you for joining us, Dahi.
Sure, thank you so much for having me.
So we heard from Jenny about the Jackson Women's Health case, and this case isn't happening in a vacuum. Anti-choice lawmakers have been working tirelessly to chip away at the right to abortion. What types of attacks are we seeing on reproductive freedom across the country, and what is their impact?
Sure. Well, first of all, I want to also start by thanking all of you for being here today. And I'm so honored to be on this panel with so many amazing folks. So thank you for having me. And before that question, I just also kind of wanted to introduce myself. So my name is Dahi Kim, and so today we're talking about abortion access for women of color, particularly for APR women. So NAPOF is the only organization focused on building power with APR women and girls to influence critical decisions that affect our lives, our families, and our communities. Using a reproductive justice framework, we elevate APR women and girls to impact policy and drive systemic change in the United States. So the term reproductive justice was actually first coined in 1994 by a group of Black women activists called Women of African Descent for Reproductive Justice, who believe that the mainstream feminist and reproductive rights movements did not meet their needs. And so for Asian American and Pacific Islanders, AAPIs, using the reproductive justice framework acknowledges the diversity within our community and ensures that different aspects of our identity, such as ethnicity, immigration status, education, sexual orientation, and gender identity, are collectively considered and not ignored when addressing our socioeconomic and health needs. And these issues must be considered in tandem because they affect our ability to self-determine our lives, our families, and our community. So, like, for example, immigration status hinders our ability to form or unite with families, while voting rights may affect our ability to translate our autonomy and decision-making to tangible benefits at work. And workplace harassment interferes with our ability to provide for ourselves. So if we can go to the next slide, that would be great. All right. Yeah, so Jenny did an amazing job of kind of like laying down the context. So I'm not going to go too deep into this. So at the federal level, as Amy mentioned at the top, the Supreme Court has a 6-3 super conservative majority, the three of whom were appointed by former President Trump. So they, like many of the lower court judges, actively were against abortion during their careers. And their opposition to Roe was like the litmus test before they got the nomination. And it's no coincidence that many of these nominees were also against reproductive justice issues fundamental for women of color, such as economic justice, immigration, and healthcare. And on the state level, like Jenny mentioned, 2021 saw the highest number of anti-abortion laws since Roe. And these laws have the impact of making abortion care more difficult. And it is disproportionately pregnant people of color and others with marginalized identities, most of which intersect with each other, being impacted by these state abortion laws. Next slide, please. Yeah, so this is what we know. Roe is a landmark case and a very important case. And despite the legal right, we know that having the legal right is different from actually accessing abortion care for many pregnant people, disproportionately women of color. Mississippi, for example, only has one abortion clinic, and other states also only have one abortion clinic. And we are worried about the impact of the ruling from Dobbs, knowing the reality of abortion access and that the legal right hasn't always come together and they haven't always translated to actual access to abortion care. So for NAPOF, as advocates for APR women and girls, we're worried about what's at stake in terms of the impact the ruling will have, because lawmakers have already shown that they will go after women of color who are trying to obtain abortions. And an example here is sex-selective abortion bans. So sex-selective abortion bans make it illegal for a doctor to provide abortion care if they suspect that a pregnant person could be seeking an abortion due to a preference for the sex of the fetus. It's a part of these so-called reason bans because reason bans which come reason bans such as race bans and fetal diagnosis bans. And proponents of these sex-selective abortion bans claim that these laws are necessary because Asian Americans who migrate to the US bring quote-unquote backward values with them, even though studies have disputed this assumption. And courts have acknowledged the reality of accessing abortion in terms of such things as childcare or taking time off. What they haven't really acknowledged yet is the barriers that are unique to AAPI women, such as language barriers and immigration access. We know that language barriers make it difficult for AAPI women to access healthcare in general, and abortion care is one of the ways in which language makes it difficult to obtain healthcare. And as for immigration status, we've seen this play out with the public charge issue. So during the past administration, public charge widened, their new public charge rule widened the number of government assistance programs that would make someone ineligible for certain immigration status. And that cast a pall on folks who needed assistance, especially due to COVID. And they chose to forego assistance, even if they were eligible for it, because they were so worried about what it may mean for their immigration status. And the targeted efforts to go after women of color seeking abortions, like through sex-selective abortion bans, casts a layer of fear that if they try to get an abortion, then their immigration status can be jeopardized. So the landscape is pretty worrisome here. But what I am getting my hope, my reason for getting up in the morning, is that we have seen that so many are willing to engage in these issues at an intersectional angle and center those most impacted and take action with empathy and boldness. So yeah, thank you all for inviting me and giving me your attention.
Thank you, Dahe. And thank you so much for the work that NAPAWF does. You all are really leaders in the judicial nomination space and in fighting these attacks at the state level. So really appreciate having you here and your expertise. Now we will move on to our last panelist, Ellen Hamilton. Ellen Hamilton currently serves as the Legislative Director for Congresswoman Judy Chu of California's 27th Congressional District, where she covers health, women's issues, mental health, and substance abuse, veterans, and oversees the Congresswoman's work on the Ways and Means Committee. Ellen handles Congresswoman Chu's work as the chair of the Contraception and Family Planning Task Force of the House Pro-Choice Caucus and as co-chair of the Integrative Health and Wellness Caucus. She also works closely with the Congressional Asian Pacific American Caucus, which Congresswoman Chu chairs, on their work on healthcare and minority health disparities. Previously, she served as senior legislative assistant, legislative aide, legislative correspondent, and staff assistant for Congresswoman Chu. She received her master's in public policy from the George Washington University and her bachelor's degree from the University of California, Los Angeles. So, Ellen, we heard from Jenny and Dahe about what's at stake at the Supreme Court, how abortion access has been restricted across the country. And it really feels more urgent than ever for Congress to take action to protect reproductive freedom and abortion access. Can you tell us about the Women's Health Protection Act, which is a bill that your boss, Congresswoman Chu, leads, and what our attendees can do to secure its passage?
Yeah, absolutely. I also want to thank everyone and NARAL for hosting this event today. I want to thank my co-panelists who are so incredibly impressive. We heard a lot about them from the problems and challenges that we are facing in terms of abortion access in this country. So what can we do? And the answer is we can pass the Women's Health Protection Act, or WIPA. So WIPA, which is HR 3755 in the House right now, is the federal bill that addresses these attacks on abortion rights happening across our country. WIPA creates or establishes a federal statutory right for healthcare providers to provide abortion care and a corresponding right for their patients to receive that care, free from medically unnecessary restrictions that single out and impede abortion access. So that's these kind of state-based restrictions that Jenny was talking about, whether it's requirements for how wide a clinic door needs to be, the waiting periods, 2-visit minimums, ultrasound requirements, all of that. The Women's Health Protection Act would create this federal statutory right so that it doesn't depend on your zip code if you have abortion access or not, because someone living in California should not automatically be guaranteed more abortion access or right to more abortion access than someone in Mississippi, for example. So HR 3755 currently has 188 co-sponsors in the House, so 188 members who've signed on to support, and 47 in the Senate. In the House, it's led by my boss, Congresswoman Judy of California. In the Senate, it's led by Senator Blumenthal of Connecticut. But what we need to do is make sure that before this case makes it to the Supreme Court, before this Mississippi case makes it there, we have protected the right to abortion through federal statute. And that means passing the Women's Health Protection Act. So last Congress, we had 216 co-sponsors. So it was the most co-sponsored pro-choice bill in Congress, which means we know we have the support to get this moving. And what NARAL advocates can do is they can contact their members of Congress or neighboring members of Congress if their member isn't as friendly to abortion access, and urge them to co-sponsor this bill. We need to show leadership and show the world that we have support, that this is a popular policy to protect abortion care, so that we can move this bill now before abortion access becomes out of reach for so many in this country. And you know, it's going to be a bumpy road. We know the Senate, we only have a 50-seat majority there, but we do have a president and vice president who are committed to abortion access. So if we can get this through the House and start moving things through now, it really will set us up well to protect abortion access, so that even if the Supreme Court strikes down Roe v. Wade, which, you know, is a threat that we're facing, abortion access all over the country would be protected with the Women's Health Protection Act.
Thank you, Ellen. It's wonderful to have you here. We appreciate the work that you do in Congress to make sure that Wipa gets co-sponsors, and definitely the energy and the power that your boss puts behind all of behind this initiative, which is so critical, especially in this point in time, as you described. So with that, we are going to move on to a Q&A session. We've received several questions from attendees. And people can feel free to keep dropping questions into the chat. I'll be monitoring those. And then I'll also be reading some of the questions that we received during the presentation. So the first question is for Jenny. Why did the Supreme Court agree to take this case, given that Mississippi's ban is so blatantly unconstitutional?
That is an excellent question, and I am not going to kind of predict or kind of think what the justices were thinking when they took on this case. But as you might recall from my presentation, they did sit on the cert petition that Mississippi asked to take up this case for 11 months. Which is highly unusual. I think that our case, or perhaps one other case that's the longest the Supreme Court has ever waited to respond to a cert petition. And I will say, absolutely, this law is blatantly unconstitutional. As I mentioned, there is no doubt about it, because all of the courts uniformly, and folks who, judges, as you mentioned, who might not be as sympathetic to our issues, they still understand the core right of Roe and Casey, which is that you have to have a guarantee to pre-viability abortion. So it is very alarming that the Supreme Court decided to take up this question. I will say there was an interesting shift. As I mentioned, Mississippi previously had not asked to overturn Roe versus Wade in their original papers, especially in their petition, and then all of a sudden changed course last week in their merits brief. And I am not going to also put myself in the minds of the Mississippi Solicitor General and the officers there. But the big difference between those 11 months, I will say, is that Justice Ginsburg passed away during that time. And Amy Coney Barrett, Justice Barrett, was put on the court. So I don't know if that played into the metric, but we are really seeing a complete about face from what their ask is. So this is, again, I cannot say enough, sound the alarm. Like, this is the explicit ask. every court has pretty much gotten it right for the last 50 years, and definitely for the last 25 years since Casey affirmed again the core right in Roe. So this is like a very stark moment that the court has decided to take this case, that Mississippi has argued it this way. And, you know, I think that we just need to keep the drumbeat, as I said, continuously for the next year or so.
Thank you, Jenny. The next question is for Dahe. So how are these accelerating state attacks on abortion access related to the wave of state attacks on fundamental rights like the right to vote?
Yeah, thank you for that question. I think these are all part of an effort to lash out against the increasing power that folks with marginalized identities have. So for example, API Woman came out in full force during the 2020 election. NAPOV actually did a poll, and we learned that API Woman voted at historic rates that are much higher than the national turnout rate. And many of them were first-time voters. So we're here and continuing to build on the work that many have done before us and seizing our own power. And considering that APIs are the highest growing population right now, our political growth is really amazing and very meaningful to me as somebody who used to organize and as an Asian American woman myself. I think it all comes down to the fact that, and those that would rather that we keep our heads down are dismayed and unhappy that we are actually getting organized and flexing our political muscles. And the attacks on our fundamental rights are part of an attempt to keep the status quo that served them better than anyone else, rather than have us boldly advocate for what we need.
Thank you. Yeah, that is so real. The next question is for Ellen. Ellen, could you tell our members why it's important for members of Congress to hear from their constituents about their support for reproductive freedom?
Yeah, absolutely. That's a great question. So as in my role as a legislative director for a Congresswoman, a lot of what we do is take meetings with the constituents of the Congresswoman who come to talk to us about any number of issues. It can be anything from, Medicare to needing help with the VA to, lowering prescription drug prices. It really varies. But the thing is, members really care about what their constituents have to say. They represent you. So when you come in to meet with your member or even their staff, if you can't get a meeting with them personally, if you meet with their staff, that is held very, very highly. They want to know what their constituents are saying. And there's various ways to get in touch with your member. I will say there is a bit of a tier. Tweeting is fine. It's not as good as a phone call, which is not as good as a letter, which is not as good as a meeting. So if you really care about an issue, you request a meeting and ask your member to support the Women's Health Protection Act, to support these issues that you care about, and to support abortion access. And members take it very seriously. Many of them will go out of the way to accommodate meetings with their constituents because that's what they're here to do. They're here to listen to you.
Thanks, Ellen. The next question is actually for you too. Attendees are asking, what is the process that Wipa needs to go through to pass? And do we have time to pass Wipa before the Supreme Court makes a decision?
Another great question. So for those of you that haven't seen the Schoolhouse Rock, I'm Just a Bill, that does actually a pretty good job of showing how a bill becomes a law. If you're too young and you didn't see that, it's on YouTube, it's great. But a bill needs to be introduced, that part has been done, then it needs to have a hearing in Congress. We did that last Congress in the Energy and Commerce Committee. We might need to do that again, and then it needs to be marked up. So it needs any changes that be made to the bill. Members can offer amendments. If it gets marked up, I would imagine Republicans would offer a lot of amendments to make the bill worse. Then once it gets marked up by the Energy and Commerce Committee, they would send it to the House floor. The House would then take up the bill, pass the bill, and then it would get sent to the Senate, and the whole process would start all over again. So that is part of why we are pressing for passage of the Women's Health Protection Act now, because all of this can take some time, and it can take a while to move these bills through, to get time on the floor. There's lots of different things happening. We have an infrastructure bill moving through. We have, the reconciliation bill that's moving through. So to make time for these, you have to kind of get all of your ducks in a row. We have, I think Jenny said 11 months. We have a little while, but that goes quickly. So that's all sort of part of the urgency of why we need to pass Wipa now.
Thanks, Helen. And yes, I mean, the person who asked the question noted, it seems like we need to work hard and very fast, and that is on point and accurate. We are getting to work quickly. We'll be talking later at our lobbying training why we'll be using our August recess to have our members meet with their members of Congress to talk about why Wipa is important. This pressure that members of Congress receive from their constituents is vital for making sure that we push for this Wipa vote to happen before next summer. So yes, we have our work cut out for us. The next question is for Jenny. Jenny, the person would like you to expand on how the right to abortion is tied to so many other fundamental rights, like the right to use contraception.
That is a great question, and I will address it, but I do want to really emphasize the things that Ellen and Amy have said. You guys pay for your Congress folks and your senators' bills, right? Like, you pay for their salary. So please go talk to them. And, I completely agree. We have until summer. The Supreme Court can decide the Jackson Women's Health case anytime between January and June. We're suspecting on the latter end because that is when, quote unquote, like controversial decisions from the Supreme Court get decided. And however way the court decides this case, I'm going to assume that there's going to be quite a splintered decision, right, with lots of different opinions and, lots of concurrences and dissents, because that's just how abortion decisions have gone in the last few years. So I really implore you, yes, take the time to really get through and talk to your senators and Congress folks and really push them to get Wipa voted on and passed. The summer is one kind of point, but even if the Supreme Court decides, obviously affirming would be fantastic. But if we get a negative decision from the court, it's going to really depend on how the decision reads, what they've done to Roe and Casey. And then, the fight's not over then, right? Because Wipa can restore access all across the country because it would be a federal law that would, then be able to supersede the Supreme Court. That's exactly what happened with the Lilly Ledbetter Act, and it can happen again here. With regards to that excellent question from one of your members, yes, so the right to abortion really emanates from the Liberty Clause of the 14th Amendment of the Constitution. So the 14th Amendment says that the government, it's really a protective clause. The government cannot take away your liberty without due process of the law. So what does that mean, right? You get like procedural due process and what's called substantive due process, and without making it too like legalese, that word liberty has been used to protect a number of rights that are so personal to your being. So that includes at the very beginning in a case called Griswold versus Connecticut, a right to privacy was recognized for marital couples to use contraception. Now, I know that's so staggering to believe that like 60 years ago, that wasn't a right, but it wasn't. And then, 7 years after that, there was a case called Eisenstadt, which extended that right to unmarried couples. Again, just to say how fresh and new these rights were, previous to that, unmarried couples were not able to have the right to contraception. After that, Roe versus Wade kind of extended that to childbearing and the right to abortion. And then so many other rights kind of emanated from this. And by that, I mean, the right to have intimate relations for everyone. So Lawrence versus Texas. Obergefell as well, the right to gay marriage is also based on this. So there's like an intertwined liberties principle that is really important because Roe is load bearing. And I really really want to, put this alarm out there that, like, yes, it's about the right to abortion, but it is intertwined with so many other rights that folks care about, that it is again disturbing that the Supreme Court has put it on the line. And this concept of liberty that the Supreme Court has understood for, I would say past Roe, right, starting with Griswold and on, abortion sits really at the set of those essential rights, and without it, liberty really can't exist, and it weakens the right for all other types of liberty principles.
Thank you, Jenny. That was a really wonderful explanation. I took some notes there. The next question is for Dahe. You talked about the litmus test that Trump used to select judicial nominees that were anti-reproductive freedom. Could you talk a little bit more about what that means? And our attendees would like to know what role judicial nominees play in stopping restrictions at the state level.
Sure, thank you for that question. As to the first question, that's pretty easy. Former President Trump himself said that. He said that his Supreme Court justices would automatically turn Roe. So there's your answer. And then we've seen that actually play out time and time again, that attorneys who actively worked against abortion access or ruled against abortion access, before they have been nominated, they were rewarded for doing that. And as to the second question, so federal lower court judges all have to go through a nominations process in the Senate. But before that, the White House, with advice of these senators whose states judges would sit on, would name the nominees. And we have seen that President Trump appointed over 200 judges in less than 4 years. And, NARAL, along with NAPAL, we fought against nominees who, as I've just mentioned, who have worked actively against abortion access. And then these judges would sit on the lower courts. And what do the lower courts do? Well, before a case gets to the Supreme Court, they have to go through the lower courts and kind of like meet that hurdle before they can ask higher courts to look at their case again. So a lot of, we've seen like lower court judges, district court judges, or appeals court judges rule against abortion access, or abortion access time and time again. So that's the way in which lower court judges and judicial nominations play in abortion access.
Thank you, Dahe. That was really helpful and a good summary of why judicial nominees matter. People wonder why we spend so much time worrying about the types of nominees that we're seeing, but it's because they're the first people that encounter these cases at the district court level. And then they reach the Supreme Court, and we are in the position that we are currently in. The next question is for Jenny, and it says, when you say pre-viable, is there currently a legal definition of that used for these types of cases?
Yeah, so that is a great question. So viability is a legal term as well as a medical term. And what I mean by that is, if you are a med student or a doctor, right, there's a definition for viability in the medical field. And that currently sits at about 24 weeks of pregnancy. And that really means when the fetus has an opportunity to live outside of the womb, either with artificial aid or otherwise, right? And if it can survive on its own or with aid. From the legal perspective, very much gathered from the medical perspective, it's about the same time. But I would also add that viability has been built starting in Roe. So in Roe, the court, as I mentioned before about liberty principles, kind of really weighed how do you kind of justify the state's interest in preserving fetal life and the interest of the health of maternal life with the individual's constitutional rights. So it's kind of like this clash. And the Supreme Court said, look, the line is drawn at viability in Roe, because that is when, the fetus can live outside of the womb and could have potentially the independence of its own liberty rights, right? Because before that, it is the right of the individual, it is the right of the pregnant person to hold the constitutional right, not the right of the fetus, and certainly not the right of the state to force someone to remain pregnant against their will. So that's why it's so important to preserve the viability line as a legal concept. And I will just add, it's not just Roe and Casey, the cases y'all have heard about. There are so many cases in between that time and time again affirmed the viability line, right? So cases like Kaladi, cases like Thornburg, cases in between. So, and I won't mention all of them, but at least 8 cases in the Supreme Court have upheld that viability line. So this is much more about, like, when I say the institution of the court and the rule of law, the court has drawn this line, right? And it is for medical reasons, it's for legal reasons, it's for practical reasons. It's a very principled, workable line that has been, again, like I said, states can put up barriers, right? We've talked a lot about them. Ellen's mentioned them, Amy's mentioned them, but they cannot ban a pre-viability abortion. And that has been true consistently. And just really, it is a line that the court has to hold.
Thank you, Jenny. The next question is bringing us back to the political side, or on the House side, the legislative branch, I should say. And they're asking, how much support does Wipa have in the House? And how many members do you need for passage?
I'm on mute. Okay, great question. So it currently has 188 co-sponsors in the House. We need it's either 217 or 218 to pass. That number depends on if we have special elections or vacancies, but 217 or 218, it's 218 when it's the full, and when there's no vacancies and it's the full House. We had 216 last Congress. So there's about 30 members, I'm not great at math, who were on it last Congress, who just haven't gotten back on. And that's another reason why setting up meetings with your member of Congress is so important. I mentioned the bill number at the beginning. It's HR 3755. That 3755 means it was the 3,755th bill to be introduced this year in this Congress. So that gives you a sense of how many bills we as staffers and as our bosses as members have to sort of sift through as things are happening. So that's why these meetings are such a big deal and mean so much, is it's helped bringing attention to something that a lot of these members might already support, but might have just missed it when it came through. Or maybe they had a special election and they were elected after we introduced the bill, and they don't know which one, they got to Congress in late June and they don't know all of the bills that, are showing what they support, but they should also sign on to and co-sponsor. So we need 218 to get through passage. I think we're gonna have 220 or 21 Democrats this Congress. So it's almost all of them, but I think we can do it.
I think we can do it too. And I think the urgency isn't lost on members of Congress who are pro-reproductive freedom. So it's just a matter of reminding them, as you said, Ellen, that this bill exists and it is a critical piece of legislation in this point in time. And the person also asked about supporting the Senate. So for the Senate, the stats are, as Ellen mentioned earlier, Senator Richard Blumenthal is the sponsor of the bill in the Senate. He is a Democrat from Connecticut, and there are 47 co-sponsors, and with him, it's 48. So also really close to the threshold that we need. So it's a matter of just getting literally a couple more, and we have the support that we need in the Senate.
Can I just jump in really quick on that?
Yeah.
With the Senate being at a 50-50 split with Vice President Harris as a tiebreaker, having a strong vote in the House, having 218 members support Wipa in the House will really help it get over the finish line in the Senate. So that's sort of why we're focusing on starting this in the House, because it's so narrow and so tight over in the Senate. We need the House support to get it over the finish line over there.
Thank you for saying that, Ellen. That is critical. That's a really important point. We just got a question that says, is there a list publicly available of the House and Senate members currently supporting Wipa? And
yes,
the answer is
I'm so glad you asked. Congress.gov.
Yes, as Ellen said, Congress.gov. The bill number is HR 3755. Is that correct? And then on the Senate side, it's S 1975. So it sounds like a year. It's easier to remember. So you can look that up on congress.gov and it'll give you a list of co-sponsors. And if you're attending the lobbying training later, we will provide a PDF where we give you a link to the congress.gov page where you can view this easily, because it is important to know whether your member is or isn't a co-sponsor when you go into these meetings. But that actually, we got to all of the questions and we are at time. So I am very proud of us for getting through so much content in such a short period of time and for getting through people's questions. So thank you to our panelists for joining us, for the depth of knowledge that you've shared during today's session. And to our attendees, we hope that you enjoyed the panel. And now we have a break in our schedule. I believe it is a 5-minute break, and we will be back at 3:15. So it's actually a 10-minute break. So we'll see you back here at 3:15 p.m. Thank you.